that. We'll try to answer them. If not, we can get back to you afterward. Um, so next slide, Surya. Just very quickly, Danziger Markov is a business and tax-oriented law firm. Two offices located, one in White Plains, one in Melville, New York. We focus on just three things. Many of you know us for our employee benefits work that we do, which is designing, preparing, and administering pension plans. The other areas where we focus on are trust and estates and taxation and corporate work. So those three areas are our focus, and do a tremendous amount of work with succession planning for our clients who own businesses. So next slide, Surya. Today we're going to be covering four separate topics. We only have 45 minutes, so we're not going to have the ability to cover everything, and we're not going to have the ability to cover everything in detail. Be glad to have a conversation with you after the presentation if you'd like. The four areas we're going to cover are buy-sell agreements, the relevant provisions within those documents and some things to think about, a sale of your business to a strategic buyer, a sale of your business to private equity, which has, as you probably know, has become much more prevalent in all aspects of our clients' business dealings. They are dipping down into much smaller transactions, and there's some unique things that need to be focused on there. And the last area, just touching briefly, is on ESOPs, employee stock ownership plans. It's a special transaction for the right client and the right set of circumstances that, if you meet those circumstances, should be explored. So getting started, next slide, Surya. Getting started, I'll start with buy-sell agreements. Gary, please interrupt me if you have anything you'd like to add. But with buy-sell agreements, obviously, every business that has at least two owners in it really needs to have a buy-sell agreement. We've seen so many circumstances where two owners get together, they've built up a really nice business, they have delayed, postponed, or ignored the agreement as between them, and then some unexpected event occurs. Someone dies, someone becomes disabled, someone just wants out of the business. And then you're sort of off to the races if you don't have an agreement between you. If you don't have an agreement between you, the worst case scenario we have seen several times is that you all of a sudden, as one owner, become partners with your former partner's spouse or former partner's family member, which has always led to disasters. So when we're preparing buy-sell agreements, we want to structure the agreement so that it works for everyone involved, so that it works for when the time comes, the withdrawing partner, and it works for the remaining partners. So while there's a lot of provisions contained in a buy-sell agreement, there are three main areas really to focus on. The first area is decision making. Most of our clients who have partners, I shouldn't say most, many who have partners want to have an equal say on all decisions. When you have two partners or an even number of partners, you could run into some problems. When you have a bigger pool of owners, we often will include a provision that says the regular decisions require a majority vote. If there's only two partners, it's going to require unanimous vote, as an example. However, big decisions will require a supermajority vote. So what does that mean? Supermajority will mean more than 50%. I'm sorry, majority means more than 50%. Supermajority will mean something larger than that. 2/3, 75%, things along those lines. And what decisions do we see typically covered by those supermajority votes? Significant things happening in the business. Opening a new office, borrowing money in excess of a certain amount from the bank, entering into equipment or real estate leases for the business, bringing in, for example, another owner that you want to bring in a partner. often will provide that it's a unanimous decision for bringing in partners depending on the size of the ownership pool. Um, so though there's not sort of a fast and hard rule what decisions are supermajority, but the concept needs to be discussed, and we provide guidelines to our clients as to what decisions we see normally included in that category. The second major category or issue that we want to focus on with the clients is how are you sharing net profit of the business? Is it strictly on equity? If each of you own 50% of the business, are you sharing the net profits in that fashion? Is any one of you who's doing more management entitled to a management fee off the top before the income is being divided? Um, Many ways to do this. Obviously, if you're an S corporation, there are some limitations because for tax reasons, but that is another point that needs to be considered when we're drafting these agreements. The last major issue that we want to make sure is covered in a buy-sell agreement is what you get when you leave. In other words, what is the value of the business that what is the value you're putting on the business when someone withdraws? And we break that withdrawal from the business in several categories. The first is an unexpected event. If someone dies or someone becomes disabled, what we typically will suggest to the client is that there is a requirement that the remaining owners buy that party out. It can be covered with life insurance or disability insurance if the client elects to purchase that insurance, which is often a good idea. But regardless of whether there is insurance to cover that obligation, it's normally a requirement. The other type of withdrawal is just wanting to leave. And normally what we're saying there is, one of the owners, for example, says, I've had enough with this business. I want to go to California and wax surfboards. I'm tired of working here. I just want out. What we're typically doing there is saying that's an option, not a requirement, but an option by the remaining parties to purchase the withdrawing party's interest in the business. It may not be a good time for the remaining parties to purchase that interest in the business. So we typically give more flexibility under those types of circumstances. Additional items to include, obviously, in the buy-sell agreement. What is the purchase price and what is the value that you're putting on the business? What Gary and I typically like to include in our buy-sell agreements is a formula that is hardwired into the agreement, so to speak. That the formula says it's a multiple of EBITDA. It's a percentage of gross income. Whatever the formula is hardwired into the agreement, and then your accountant will then apply that formula to the then profit and loss statement of the business or balance sheet of the business, and the purchase price is determined. You the client, or more importantly, or as importantly, I should say, the accountant may have a better idea than we do on what that formula should be. We do hundreds of these types of buy-sell agreements a year for clients, but each industry is different, and there's a going rate from time to time as to what the formula should be. So we'll typically lean on the client and the accountant to help us with that, establishing that formula. If the purchase price, whatever it is not to be paid at closing or at the time the withdrawing partner leaves, which we'll get to in a moment as to the pros and cons of that, we'll have to talk about collateral to assure that the withdrawing partner gets their money. Is that going to be a personal guarantee of the remaining owners? Is that going to be a lien on the assets of the business? Is that going to be other security? Is it going to be life insurance on the remaining owners? Because if they die, the withdrawing owner wants to get paid. All of these things need to be discussed to assure that the withdrawing partner is getting paid what is due to him or her. Often in these agreements, we structure the transaction so that when the withdrawing partner leaves, that he or she is done, that there is no future liability, they're indemnified from any personal guarantees they made for company obligations, and that they can go and retire if that's what they're doing, um, without a worry. There are, however, some things that the remaining partners may insist that the withdrawing partner remain on the hook for. An example um, would be if there is a tax audit during the covering the period that the withdrawing partner was a partner of the business, and the company needs to pay back money to the IRS. The withdrawing partner had expenses that he put through the business that are now being denied, as an example, by the IRS. Oftentimes, the withdrawing partner will need to stay on the hook for that, but those future liability issues are often limited. Um, One of the last issues that we are important issues, I should say, that we want to include in this agreement is covering the following scenario. Gary and I are partners in a business. I give notice to Gary that I want out. Gary buys me out for $1 million, and 6 months later, Gary sells the business for $5 million. That's not fair. And what we say in our agreements is typically is, Gary, if you then sell the business to a third party within a certain period of time after I leave, a year, 18 months, something like that, I get my share. So you sell the business for 5 million, give me $1.5 million, the million I got plus the other 1.5 to get me my 2.5 million, so that I'm made whole and you didn't benefit from that timing of that transaction. In the last area, we also want to protect the ongoing business and the remaining partners. And the reason obviously is that if the purchase price is too rich, if the payment terms are too accelerated, it's going to be difficult for the company or for the remaining owners to pay the withdrawing partner. And if that happens, everyone loses. So what we would typically suggest to the clients is that the payments are structured so that there is a payout. Is it 3 years? Is it 5 years? Whatever the case may be, with the accountant's help, structuring it so that we know that if business goes as we intend, we're going to be able to make those payments. And lastly, to protect the remaining owners, we're going to have that the withdrawing owner sign a non-compete. And the non-compete will protect the remaining owners and the business, that they're not going to be running into competition from their former partner while they're paying out all this money to the former partner. So with that being said, buy-sell agreements obviously covered somewhat quickly. Why don't we move to the next category that Gary will discuss?
I don't mind if I can just jump in for a moment.
Sure.
Just two additional thoughts on everything that you've so nicely presented. But in terms of the potential buyout, there's, I think, one other circumstance which is treated often a little bit differently. And again, each one of these deals is very fact specific, and they're not cookie cutter. And we really do invest the time in learning the client's business, learning the client's wishes. But that's retirement, as opposed to just, I'm going to go and wax surfboards in California. But a retirement category, which would be something like, as long as you've reached the age of 65 years of age and you've worked for 30 years for the business, you're entitled to retire. And sometimes you get some extra goodies on the way out the door as a reward for the longevity of your services. It's important to look at the age of the partners, because if the partners are all of similar age and will all sort of reach the retirement eligibility point together, you then have what we refer to as a race to retirement, where you're fighting over, throwing your retirement notices at each other and trying to figure out, well, who threw it first. So again, just another category to think about in these deals. And again, fact specific depending upon the ages of the parties.
Excellent.
And the one other little point in terms of the decision making and the compensation is I've had a lot of clients come to me saying, well, I'm going to be the 51% equity owner and my partner is going to be the 49%. So I get to make all the decisions because I'm the majority owner. And that's, as Bob was suggesting, an understandable thought, but not necessarily a correct thought, because you still, through this agreement, can um, apportion compensation and decision making um, based upon agreement, not necessarily, you know, in lockstep with equity ownership amounts.
Excellent. So, nope, go to the previous one. Sorry, there we go. So I think, Gary, you wanted to discuss at this point the sale to a strategic buyer.
Sure, sure. So, as I was just saying with the buy sell, this is all very fact specific, and some of the um, influencing factors in terms of a buyer is, why are you looking to sell? Are you looking to sell the whole thing? Um, are you maybe in a very unique industry? So if you're looking, for example, to bring in a new partner, well, then you're selling some portion of the ownership. You're not selling the whole thing. And then again, who is that person going to be? Is that a person bringing a particular talent that you need for your business? Or is that person going to be bringing in just an infusion of cash? Um, the choice of person is going to be somewhat different, or the choice of entity as a purchaser would be somewhat different. And again, that then goes back to the prior segment on the buy sell, which is whatever that relationship is now needs to be codified in an agreement. But assuming you want to sell the whole business because you want out. Um, Depending upon your industry, you may want to start by making inquiries within your industry. It's not uncommon that businesses are sold to competitors, or if there's some big player in your particular industry, you can sell to that big player. Um, and then, of course, there's also um, the venture capital world, private equity, which we'll talk about in a few moments as a potential buyer. There's also the question of, do you want to continue to maybe work for some period of time in the business post sale? Um, if a buyer is buying the business because they view the business as a good investment, but the buyer doesn't have the requisite skill to actually run the business or the desire to run the business, they may want to keep you working for some period of time. And um, it may be a long period of time, or it may be an interim period of time until a new management team is brought in. If it's someone who's in the same industry, they're probably more interested in your equipment, in your business relationships, and they've got the know-how to actually take over the business. Um, Once we've got a buyer identified, and of course there are business brokers who can also assist in locating buyers. Um, they can be very effective. They can also be very expensive. So it depends upon, um, again, the unique factors of your situation to determine how best to locate that buyer.
Gary, just jumping in here just for a second. What we've been finding, guys, about finding a buyer is investment bankers play a very significant role in finding and structuring transactions. And they are valuable. As Gary said, the fees can be high. However, they are only looking to do, several $1 million transactions, $10 million plus, maybe something like that. So it may not, depending on the size of your business, you may not be able to, get that option. Calling a lawyer who does a lot of this work, calling your accountant as well, is also a good way that many of our clients have found a buyer if they're looking to sell their business.
Yep, that's absolutely a great point. Thanks, Bob. Once you've got your buyer, we're now starting to get into sort of the nitty gritty of how do we structure the sale. And there are basically two forms of a business sale. One is an equity sale where you're selling the ownership interest in the entity that owns the assets of the business. The other option is to not sell the equity of the entity that owns the business, but just to sell the assets of the business. Most buyers prefer to buy assets. In fact, I would say most buyers insist upon only buying assets because they do not want to inherit any potential liabilities that could be lurking somewhere out there against the selling business as an entity, where if you're buying the assets, obviously they have to be free and clear of liens and so forth. The buyer is protected from those potential liabilities, and so that's usually the way these deals work. There's also a benefit in some instances to the seller to only sell the assets and to retain the ownership of the business entity. Because one of the things that we do at our firm is offer clients some very unique, potentially dramatically beneficial pension options where a defined benefits plan may be something that can work. Again, there's a lot of different considerations into whether or not you qualify for that, but our actuaries are really expert at figuring that out. And so there's a benefit by actually holding on to the ownership of the entity after it's sold off all of its assets. So again, it's on a deal specific consideration, but there's definitely benefit to the transaction being an asset transaction. And then obviously the big question is purchase price and how are we getting paid? So as Bob mentioned, the purchase price is often based on an EBITDA or some other formula. But once the purchase price is established, the question is, how am I getting paid at closing? Is the buyer going to just write me a big fat check and we're done? Is the buyer going to say, well, we can't pay you the whole thing, but we'll give you a note. In other words, some seller financing component is involved. And there, obviously, we're talking about what proportion of the total sales price is going to be payable over time pursuant to a promissory note. And how do we secure that payment? Just simply the note in and of itself obviously has some value in that it's the evidence of a legal obligation and it comes with legal rights that if they default, you can sue them. But we typically want more than just the right to sue. So we're going to want some collateral or some security agreement that raises the level of protection to ensure that that our position as a creditor at that point is secure. And the other,
Eric,
yeah.
I'm sorry, just jumping in just for a second. Because of the banking environment now, and the low interest rate environment, Gary, is it fair to say that a vast majority, if not almost all of our transactions, other than private equity, um, it's pretty much cash at closing for the buyer? I mean,
Yes,
for the
yes.
seller rather?
Yeah, that's absolutely been my experience. Banks are lending quite freely at the moment, and if there's a combination of bank loan and then seller financing, that makes it a little bit riskier because you're always going to be behind the bank. The bank is never going to permit you as a creditor to somehow leapfrog over them and take first position. So, in order to ever collect on that second position, you first have to take out the bank, who's invariably most likely lending more money than what you, in a sense, are lending. So, that's an issue. The other thing we're seeing, particularly when we're looking at the private equity deals, is some portion of rollover equity. So we've agreed that the price is $1 million. We'll pay you $800,000 and give you $200,000 of equity in the buying entity. Um, Again, what is this buyer? Who is this buyer? What are their resources? What are their business plans? Um, is that a good investment or is that not a good investment? And again, with many of these issues, it's the old expression, the devil's in the details. Yes, it sounds great to say we'll give you some equity position, but what does that mean? What are the strings that are attached to that? How can you get out? You say, you know what, I don't like the direction that you buyer are going. I want out. Very often it's not easy to get out. So these are certainly going to be factors to be considered in the overall deal. And as we said earlier, what is the post-closing requirement that the buyer is going to want from you? Do they want you to work? Do they want you to not only not work, but sign on to a non-compete agreement, agreeing not to work? Because, in fairness to them, if they're paying you a sizable amount of money to buy your business, it would be inequitable for you to then be out there competing against them with all of your relationships and all of your know-how after they've just paid you a chunk of money. So a lot of balancing of equities and interests go into these agreements. Um, and with the respect to tax considerations, as I said, we may be able to fit you into a defined benefit plan that can be helpful from a tax perspective. But at a minimum, the allocation of the purchase price needs to be negotiated and agreed upon. Sometimes buyer and seller are at odds as to how you want to best allocate the purchase price so that it's got most beneficial tax treatment to you. And the parties do have to agree to that in the underlying agreement to avoid any inconsistencies in how the buyer may treat the transaction from a tax perspective and the seller may treat the transaction from a tax perspective. Because when everyone starts to file their tax returns, if there are inconsistencies, it's a recipe for some pretty significant headaches.
So just to jump in there just real quickly on the tax issues. Um, Obviously, we are concerned about when we're representing the seller of a business, what the seller is receiving for the business that they're selling. But as important, if not more important, quite frankly, is what is the net amount after tax that our client is going to be getting. So a great deal of time is spent on these tax issues, these tax allocation issues, as Gary rightfully pointed out. Generally speaking, when a client of ours is selling their business, we want to allocate to the assets that are going to be treated for tax purposes as capital gain. In the current environment, capital gain between federal and state is about 25%, give or take. Ordinary income, we know, is much higher than that. So we're trying to allocate as much as we can to those capital assets that we're selling. Goodwill, things along those lines that will be treated at the lower tax rate. To amplify what Gary also said, because of our pension work, what we're also able to do is to have the client consider if they want to be able to shield some of the purchase price through implementing a defined benefit plan in the year of the closing. So giving you an example of this, what recently happened, I think it was just last week. We sold a business for about $2 million, one owner. Because of the age of the business and because of the age of the owner, and various other facts and circumstances, our actuary was able to design a pension plan for our owner, who's around 65 years old, to shield about $1 million of that purchase price. So really, if we were able to shield $1 million in a defined benefit plan, that's free of tax. And then the other $1 million, we tried to get as much to goodwill, to capital gains treatment as possible. So the net profit result, so to speak, or the net proceeds result, was very good for the client. So something to keep in mind if this is the way that you're thinking of going. Gary, is there anything more that you want to discuss on the private equity piece? Moving to the next slide.
Yeah, so Tsuru, if you want to just advance to the next slide, I think we've pretty much covered most of these issues, but the very last point on the slide is pros and cons. And depending upon the nature of the business and frankly your business philosophy and your wishes and desires for your business, private equity sometimes comes in and doesn't necessarily have the sensitivity to the nature of your specific business. They are generally money people. They're focused on the money. They're focused on the balance sheet, and they're focused on what can we do to maximize that revenue. And that can sometimes create some tension, particularly if you are going to stay on as an employee in the context of a professional practice. Let's for example use a radiology practice. The radiologist who's now and I'm using the word very loosely, partnered with a private equity firm, because you can't actually do that. It's another whole structure, but just for purposes of illustration, let's say there's a new X-ray machine that gives a clearer image and makes the doctor's life a little bit easier, but it's an expensive investment, and the reimbursement rates are no different than with the current machine that the practice is using. You now have to go to the private equity entity and say, hey, I'd like to invest in this new machine. It makes my life easier. They say, well, does it increase revenues? No. Well, you'll make do with your old machine. That's sort of a simplistic example, but you're now answering to people who have potentially a much more narrow interest in your business than you did, or that you do if you continue to own. It may very well be that if you're completely out, you don't have to worry about it. But again, it's who you're doing business with, and it's going back to how you find your buyer. What's their business philosophy? What's their track record? What are their future plans? All of that due diligence, as we call it, really needs to happen to make sure that you're comfortable with the transaction the transaction will be a success.
So just coming back for a second, Gary, on private equity and the concept of rollover equity. So I just wanted to maybe put some meat on the bones there. So many of our clients who have sold to private equity, the formula is typically give or take, not a hard and fast rule, but the private equity shops will say, we'll give you 80% in cash, seller, and we're going to require that you use 20% of the purchase price. We're going to give you equity in our entity, in the buyer's entity. And many of our clients, they have to do a deep dive into who that buyer is. I'll give you some things to think about. One is, many times a private equity shop will create a subsidiary to buy your business. And that subsidiary, the only thing in that subsidiary, the asset that's in that subsidiary, is your business. So you have to have confidence in the buyer. They can run your business as well as you did for you to get money out of that 20% equity when they subsequently sell the business, or whether there's a big bang later for them to liquidate that business. It would be better, and we've had a lot of difficult conversations with these private equity buyers, that no, we don't want the 20% equity in this subsidiary that you just created out of thin air. We want 20% equity in the mothership. And we want it in the main business that you have, so that it's not just the upside of my business, it's the upside of your entire roll-up of all of the companies you've bought. Most of our clients, when they're looking at private equity, will say to themselves, and this is a conservative way to look at it, but will say to themselves, if I don't get anything out of that 20%, I'm good with the purchase price that I got at closing. And anything I get for that 20% rollover equity is gravy. And if you have confidence in the buyer that they're really going to make a go of your business coupled with the business they already have, it may be worth rolling the dice. But these are the types of things that you need to consider if you're marching down the path with private equity, and we can spot some of these issues for you if you'd like. Surya, I want to be mindful of time. Why don't we go to the next slide and touch on this ESOPs. So ESOPs, we held a program just yesterday about this in much more detail, but this is a business succession planning option that is very intriguing. And because of the nature of our firm with pensions, corporate, and estate planning, we advise clients on this transaction a great deal, because an ESOP really covers all three of those areas. So big picture, and again, I have 5 minutes to talk about this, which won't do it justice, but big picture is a candidate who could consider an ESOP, because of the nature of the transaction, the complexity, the expense of the transaction, have the following characteristics. Number one, they have 15 or more employees. Various reasons for that, which I can't go into now, but it goes into testing, various discrimination testing that our actuaries need to do. That's the first criteria. Second criteria is that the EBITDA of the business, including shareholder compensation, is at least $1.5 million. And the reason for that is that the multiple that the valuation company will put on the business will be dictated by EBITDA. So 2 times EBITDA, 5 times EBITDA, 10 times EBITDA. You need a certain threshold to be able to make this transaction worthwhile. And third criteria is that the balance sheet of the business is not highly leveraged. An ESOP in general is going to be a leveraged transaction. There's going to be a bank involved that's going to lend money to the ESOP to buy the shares from the selling stockholder. So if you meet those 3 criteria, that would be something, an ESOP would be something that you, as the business owner, could consider. Again, quickly, there are misconceptions about an ESOP. When you implement an ESOP, the employees of your company don't own the company. The way an ESOP works is that the seller or the selling stockholder creates a buyer out of thin air. And what that buyer is a tax qualified pension plan. An ESOP is a qualified pension plan, which invests in your company's equity. So your employees are participants in the ESOP. They don't own the stock. They just their stock is in accounts for them. So the participants, your employees, don't vote. They don't have any control over your company after you sell it to the ESOP. And it's so that's a misconception that often people think that if I sell to an ESOP, my employees now control or own my company. Not the case. The benefits of an ESOP are, number one, you can sell a portion of your business, your stock, to the ESOP. Rarely in this environment will you find someone to come in and buy a minority interest. So an ESOP allows you to do that. You could sell 30%, 40%, 50%, whatever percent you want, typically starting at 30% for various reasons. If it goes well, then do another sale later and keep going. You control the business after you sell the stock to the ESOP. Number three, you take money out of your company and you diversify your financial portfolio. Most of our clients have the vast majority of their net worth in their business. So what is nice to be able to say to themselves is, you know what, my business is worth $10 million, God willing. I want to take, if something happens to me, I'm not going to get this money out of it. Let me take $3 million, sell 30% of my stock to the ESOP, take $3 million and give it to my broker so that he can invest in stocks and bonds or whatever you want to do with it. A nice opportunity there. It incentivizes your employees. A well-structured ESOP, the more the company grows in value, your employees will benefit from that when they eventually retire. But possibly the most important piece of this transaction are the tax benefits. One stunning tax benefit, and this is all codified in the Internal Revenue Code. It's been around forever. If you structure the ESOP properly, the selling shareholders will not pay tax on the proceeds of sale. So let me just repeat that. Unlike a transaction where you're selling to a private equity shop or you're selling to a strategic buyer, taxes are a main component of what we're planning around. When you're in an ESOP environment, if structured properly, you may never pay tax on the proceeds that you receive for the sale of your stock. The other piece is that, as I mentioned, the other incredible tax benefit for an ESOP is that, as I mentioned, you have a bank loan, and the bank needs to be paid back. As all of us know, when you pay a bank loan back, the only thing you can deduct is interest. You're never allowed to deduct the principal. Guess what? In an ESOP setting, you get to deduct the principal. So it's a stunning tax advantageous type of transaction, which if you fit those criteria, should be explored. If it doesn't work, we can go another avenue, but this is something that should be talked about. ESOPs and estate planning, just very quickly. Once an ESOP is established, there's a lot of great estate planning tools that we can get involved with gifting because the value of the company is reduced, and so on and so on. So again, we've sort of run out of time, but there's a whole subject on that topic as well. So we're running into the deadline as far as finishing with time. Sorry, the last page, if you would. Please feel free to contact Gary or me if you have any questions. Our contact information is here. Surya will be sending you this PowerPoint presentation so that you have it. This seminar will be posted online, or I'm sorry, on our website, if you wanted more information or wanted to hear it again for some reason. And we thank you for attending. Everyone have a good rest of the day.
Thank you very much, and feel free to reach out to us.
Thanks, guys. Bye-bye.